The clock on the wall reads 11:47 p.m. A man sits on a narrow cot in a concrete cell measuring 6 feet by 9 feet smaller than most bathroom floors. He has been in this room alone for 11 years. He knows every crack in the ceiling. He has memorized the rhythm of the guard's footsteps. And tonight, for the first time in over a decade, he will leave this cell for good. Not because he was exonerated, not because he was pardoned, but because in 30 minutes, the state will end his life. This is what death row actually looks like. Not the Hollywood version, the real one. There are currently over 2,000 people on death row in the United States. They live in a legal and physical limbo that most Americans know almost nothing about. A world governed by rigid routine, years of waiting, and a system that, according to researchers at the Death Penalty Information Center, has sentenced at least 190 people who were later proven innocent. To understand what life and death on death row truly means, you have to understand the institution itself, how it was built, how it operates, and what it does to the human beings inside it. The modern American death row as we know it was largely shaped by a single Supreme Court ruling. In 1972, the court's decision in Furman v. Georgia effectively halted all executions in the country, ruling that the death penalty as then applied constituted cruel and unusual punishment under the Eighth Amendment. For 4 years, executions stopped entirely. Then in 1976, Greg v. Georgia reinstated capital punishment under revised sentencing guidelines. States scrambled to rebuild their protocols. New facilities were constructed, new rules were written, and a new kind of incarceration was formalized, one defined not by rehabilitation, but by waiting. Today, death row exists in 37 states, as well as under federal jurisdiction and military law. Each state runs its program differently. Texas, which has carried out more executions than any other state, over 570, as of early 2025, keeps its death row population at the Pulaski unit in Livingston. California, which has the largest death row population in the country at over 600 inmates, has carried out only 13 executions since 1978 and has had an official moratorium in place since 2019. The people held in these facilities are, statistically, overwhelmingly male. Women represent fewer than 2% of death row inmates nationally. They are disproportionately Black and Latino. Many come from backgrounds marked by poverty, trauma, and inadequate legal representation. According to the American Civil Liberties Union, more than 90% of death row inmates could not afford to hire an attorney at trial and relied on public defenders or court-appointed lawyers, some of whom were later found to have provided grossly inadequate representation. These are the people the system has decided must die. This is how that system actually works. They spend 22 to 24 hours per day in that cell. Meals are delivered through a slot in the door. Exercise, when permitted, takes place in a small enclosed cage, sometimes indoors, sometimes in a concrete yard. Human contact is minimal. Journalist Carrie Blakinger reported inmates describe isolation's psychological weight as defining their existence. The average time spent on death row before execution is now over 18 years. Some inmates have waited more than 30 or 40 years. Thomas Knight of Florida waited 39 years. Raymond Riles of Texas was removed from death row in 2021 after 45 years due to incompetence. Federal courts have granted relief, vacating sentences or ordering new trials. In others, execution dates are set. When an execution date is finally scheduled, the final phase begins. Inmates typically receive increased contact, visits from family, clergy, attorneys. The execution itself, in states that use lethal injection, follows a protocol that appears clinical and controlled. Corrections officials argue this process is humane. Medical organizations maintain physicians should not participate. In 2015, the Supreme Court's decision in Glossip v. Gross upheld Oklahoma's use of midazolam, despite experts arguing the drug was inadequate to prevent the inmate from experiencing suffocation and cardiac arrest. Justice Sonia Sotomayor's dissent described the ruling as accepting a method that may well amount to burning alive from the inside. First, the death penalty does not appear to function as a deterrent to homicide. According to a 2012 review by the National Research Council, studies on deterrence are fundamentally flawed. States that abolished capital punishment have not seen statistically significant increases in their murder rates. Second, the system is demonstrably inconsistent in its application. Race, geography, and legal representation significantly influence who receives a death sentence. Studies show defendants killing white victims were more likely to receive a death sentence than those killing black victims. This disparity has been documented consistently across decades of study, highlighting systemic issues within the justice system. Third, wrongful convictions are not rare edge cases. Since 1973, over 190 people have been exonerated from death row. This happened after evidence emerged of their innocence, according to the Death Penalty Information Center. This figure includes people freed due to DNA evidence, recanted witness testimony, and proof of prosecutorial misconduct. Researchers estimate that approximately 4% of all death sentences in the United States are imposed on innocent people. This figure, if accurate, means the system has almost certainly executed innocent people. Former Illinois Governor George Ryan, a Republican who supported capital punishment, cited these concerns. He declared a moratorium on executions in Illinois in 2000, after 13 death row inmates were exonerated. He later commuted the sentences of all 167 people on Illinois' death row to life imprisonment before leaving office. Ryan said, "I may not know if the justice system has ever executed an innocent man, but I strongly believe we do not have the tools to ensure that every person on death row deserves to be there." As of early 2026, the legal landscape around capital punishment in the United States remains in a state of significant flux. More than 20 states have formally abolished the death penalty, most recently New Mexico, Connecticut, Maryland, New Hampshire, Colorado, and Virginia. Several others have official moratoriums in place. At the federal level, the Biden administration had halted federal executions. This followed a series of 13 federal executions carried out at the end of the Trump administration in 2020 and 2021. This was the largest federal execution spree in over a century. With the return of the Trump administration, federal executions are expected to resume. Among the most closely watched cases is that of Richard Glossop in Oklahoma, whose case gave its name to a Supreme Court ruling. He has faced multiple execution dates over more than 2 decades. His case has attracted bipartisan concern about possible innocence. His story is emblematic of the uncertainty that hangs over the entire system. For the families of murder victims, the calculus is deeply personal and does not reduce to policy statistics. Some advocate for execution as a form of justice and closure. Others, including murder victims' families for reconciliation, argue differently. They argue that the prolonged legal process of capital cases, stretching over decades, prolongs rather than relieves their suffering. They believe life imprisonment would provide accountability without the endless cycle of appeals and execution dates. In 2023, the United States carried out 24 executions across 6 states, the highest annual total in several years. Public support for the death penalty, while still present, has declined steadily from its peak in the 1990s. Gallup polling showed over 80% support, to approximately 53% in recent surveys. Support drops significantly when pollsters offer life without parole as an alternative. The international context is stark. The United States is one of only a small number of developed democracies that retains capital punishment, alongside Japan. Every member nation of the European Union has abolished it. Amnesty International's annual reports consistently rank the United States among the top executioner nations globally, alongside China, Iran, Saudi Arabia, and Egypt. Reform efforts are ongoing in multiple states. Advocates push for legislation requiring corroboration standards for eyewitness testimony, mandatory DNA testing, and prohibition for those with severe intellectual disabilities or serious mental illness. Several states have passed versions of these reforms. Others have resisted them. The man strapped to the gurney at 11:47 p.m. did not get to see how this debate resolves. He did not live to see whether the system that sentenced him was ultimately judged just or unjust by history. For him, the clock simply stopped. That is the ultimate truth about death row. It is a system built on the premise of certainty in a world where certainty is something we have never been able to guarantee. As 200 exonerations have shown, the question the system forces us to sit with is not merely whether some people deserve to die. It is whether any institution built by human beings with human error, human bias, and human failure built into its foundations can be trusted to make that decision without mistake. So far, the evidence suggests it cannot. What we do with that knowledge is the question that remains. In February of 2015, Glenn Ford walked out of Louisiana's Angola State Penitentiary after 30 years on death row. He was 64 years old. His hands trembled from arthritis, and cancer had spread through his body untreated for years. He sat in a 6x9 cell, waiting to be executed for a murder the state now admitted he did not commit. A prosecutor apologized. Glenn Ford died 14 months after release, receiving no compensation from the state, not $1. This is the story of what wrongful conviction on death row actually looks like, and the broken machinery that creates it. It forces the most uncomfortable question. What happens when the person strapped to the gurney is innocent? Since 1973, 193 people have been exonerated from death row in the United States. These are people convicted, sentenced to death, spent years in prison, and later proven wrongfully condemned. If a key witness hadn't recanted or DNA preserved, most of them would be dead. To understand how this happens, we must see the vulnerabilities of capital cases, making wrongful convictions statistically inevitable. Florida, Illinois, and Texas have the highest number of death row exonerations. These states also have large death row populations and aggressive capital prosecution histories. Factors include false confessions, incentivized informants, eyewitness misidentification, flawed forensics, and inadequate legal representation. These factors cluster and compound within a system where pressure to convict can be overwhelming. This is where the stories of the wrongfully condemned begin. Henry Lee McCollum, 17, was questioned in 1983 about a girl's murder in Robeson County, North Carolina. McCollum, intellectually disabled, was interrogated for hours without an attorney present. He signed a confession. His half-brother, Leon Brown, 15 and also disabled, signed one too. Both were convicted and sentenced to death. Justice Scalia cited McCollum's case as justification for the death penalty. He sat on death row for 30 years. In 2014, DNA evidence from the crime scene never properly analyzed, was tested. Henry McCollum received a pardon of innocence and a financial settlement. He spoke publicly about his unimaginable life inside. He described decades of waking up not knowing if a death warrant would be signed, yet holding on to hope for truth. The McCollum case had physical evidence and DNA. Many cases are not resolved by a single piece of biological evidence. They are resolved through painstaking reinvestigation, taking decades depending on a committed attorney or journalist. The case of Cameron Todd Willingham in Texas is what happens when no one gets there in time. Willingham was convicted in 1992 of setting a fire that killed his 3 young daughters. The prosecution's case rested on fire investigators' testimony, pointing to clear indicators of arson. Willingham maintained his innocence throughout his trial, appeals, and years on death row. He turned down a plea deal that would have spared his life, refusing to confess to killing his own children. He was executed by the state of Texas on February 17, 2004. 5 years after his execution, an investigation by the Chicago Tribune and David Gran revealed the truth. Independent fire science experts concluded the investigation was based on folklore and outdated methodology. The indicators of arson are now understood to be consistent with accidental fires, not reliable evidence of accelerants. The Texas Forensic Science Commission commissioned an independent review. An expert concluded that state fire investigators had not followed the scientific method. 4 days before the report was public, Governor Rick Perry replaced key commission members. This effectively delayed the process, and the commission could not definitively conclude Willingham was innocent. Cameron Todd Willingham cannot be exonerated. He is dead. Texas has never acknowledged executing an innocent man, despite his former wife's public claims of innocence. His case remains one of the most intensely debated in American capital punishment history. Research reveals how these cases happen is both systematic and damning. A 2020 study analyzed wrongful conviction rates in capital cases. Their estimate: approximately 4% of all people sentenced to death are factually innocent. This suggests over 300 innocent people have been condemned among 8,000 death sentences. False confessions are a more significant driver of wrongful conviction than expected. The Innocence Project states false confessions contributed to 30% of DNA exonerations. Conditions producing them include prolonged interrogation without sleep, food, or an attorney. Interrogators trained in the Reid technique use psychological pressure and deception. Suspects with intellectual disabilities or mental illness and juveniles are particularly vulnerable. The role of jailhouse informants, claiming confessions for reduced sentences, is equally troubling. Northwestern Center on Wrongful Convictions found false testimony from informants is a leading cause. These witnesses have every incentive to lie and are often not subjected to rigorous cross-examination. Forensic evidence, once the gold standard, has also come under sustained scrutiny. Fields like bite mark analysis, hair microscopy, and arson investigation lack empirical foundation. The FBI acknowledged in 2015 that its hair analysis examines overstated certainty for decades. This included at least 32 capital cases where defendants were sentenced to death. The current landscape of wrongful conviction law is evolving, but unevenly. The Innocence Project, founded in 1992, has used DNA testing to exonerate over 240 people. This number understates its impact, as most cases lack biological evidence for testing. Several states established conviction integrity units (SIUs) to review potentially wrongful convictions. Dallas County's CIU, established in 2007, produced more exonerations in its first years than its entire history. But access to post-conviction review remains deeply inconsistent. Legal barriers to new evidence are high. Some statutes impose strict deadlines. Federal courts generally decline to serve as a safety net. The Supreme Court ruled in Hera v. Collins that actual innocence alone isn't enough for federal relief. Justice Harry Blackmun, dissenting, wrote that the majority's position was perilously close to condoning murder by the state. For many on death row, their fate depends less on truth than on finding a willing attorney. Law school clinics, underfunded nonprofits, and a few private attorneys handle most post-conviction work. The American Bar Association found capital defense representation often falls below minimum standards. Glenn Ford died of cancer in June 2015, 14 months after walking out of Angola. He gave interviews in his final months, Speaking with startling directness, he said he was angry, a precise description of what 30 years of wrongful imprisonment produced. He missed his children's lives. No apology could reach backward through 3 decades. C. Militars, Marty Stroud, the lead prosecutor, wrestled with doubts before apologizing publicly. He acknowledged focusing on winning, not adequately investigating, and his mistakes cost an innocent man 30 years. "I failed," he wrote, "as a prosecutor. And as a human being, Ford received no state compensation before his death due to a technicality." These cases describe structural conditions making error not only possible, but likely. Pressure to solve high-profile murders, reliance on discredited evidence, and resource gaps contribute. Reversing a capital conviction once handed down is near impossible. Since 2020, several states passed legislation expanding DNA testing access. They strengthened informant testimony disclosure and mandated recording of interrogations. These reforms represent genuine progress, but they do not reach backward to cases already decided. The Death Penalty Information Center maintains a list of individuals executed despite significant doubt. This is not a list of confirmed innocent people. The standard of proof for exoneration is high. Many cases turn on disputed, degraded, or simply gone evidence. But these names sit at the center of the most serious charge against any justice system: that it has killed people it had no right to kill. There is a legal principle: it is better that 10 guilty persons escape than 1 innocent person suffer. The number of people exonerated from American death rows since 1973 is 193. This is nearly 20 times 10. Each case is not a flaw in an otherwise sound machine. It is the machine working exactly as designed, still arriving at the wrong answer often enough, sending innocent people to the execution chamber. Some got out in time. The names we will never know are the ones who didn't.